All right, let's unpack this. We're looking at a uh, truly volatile environment in the Australian workplace right now.
Hmm.
You've got these foundational employee rights, under the Fair Work Act and equal opportunity laws.
Right.
And they are just colliding head on with, well, one of the most unpredictable and disruptive forces we've ever seen, artificial intelligence.
It's more than just disruption. It's a chaotic collision, and it's exposing some critical failures.
And not just for employees.
Not at all. It's for individual workers trying to protect their jobs, sure,
Yeah.
but also for huge corporations and even, high-priced government consultants.
So what are we looking at for sources today?
We have a whole stack of articles and recent case documents. They detail the huge scope of Australian employee disputes, toxic workplaces, dismissals, discrimination, all of it.
Okay.
But what really provides this startling context are these recent judicial decisions that illustrate and this is a quote, the obvious danger of relying on AI when serious workplace matters are at stake.
So our mission today is pretty straightforward then. We're going to give you, the learner, a comprehensive shortcut into this complex legal landscape of Australian employee rights.
They'll show you the specific areas where employees frequently stumble and, end up losing their claims.
And crucially, we're going to analyze exactly why AI is proving so shockingly unreliable, not just for legal advice, but for corporate strategy itself.
We're moving beyond the hype. We're looking at the cold, hard facts.
Mm-hmm.
What happens when algorithms meet statutory deadlines and, well, integrity requirements?
Here's where it gets really interesting, because before we even get to the AI disasters, we have to understand the sheer complexity of the landscape that employees are trying to navigate in the first place. When we talk about workplace disputes, the emotional and logistical toll on an employee is often just immense.
Oh, absolutely.
These aren't just HR paperwork issues, right? They're career-defining events. You could be facing sexual harassment, a misconduct investigation, or, being forced out of a job you thought was secure.
Precisely.
Yeah.
And that complexity, that emotional stress, it often means employees feel completely overwhelmed. They just don't know where to turn.
Which is where specialized help comes in.
Exactly. This is why specialized workplace relations firms exist. They focus on providing high-level support and representation to help employees find their voice.
To get some justice and closure.
Yes, and they really emphasize that the system is complex and procedural.
And the range of claims these representatives handle, it really shows the pressure modern workers are under. It's not a one-size-fits-all problem, is it?
Not at all. Let's break down the three major types of dismissal claims because they get confused constantly and the rules are so different.
Okay.
The one most people know is unfair dismissal.
Right.
That's relatively straightforward. Was the dismissal unjust, harsh, or unreasonable? Did the employer have a valid reason? And crucially, did they follow the right process?
That sounds like it would cover most firings, but where does it start to get more complex?
It ramps up dramatically with general protection disputes. Now, this is a far more serious area of law.
Okay.
This is where an employee faces what's called adverse action. And that can be anything from a demotion to a termination because they exercised a specific workplace right.
And what's an example of a workplace right?
Oh, it could be anything from filing a complaint about safety, taking personal leave, participating in lawful industrial activities, or even just inquiring about your entitlements.
And in those cases, the burden of proof is different.
It often shifts to the employer. They have to prove that the adverse action was not taken because the employee exercised that right. Getting a general protections claim right is incredibly complex and very time-sensitive.
And then there's that truly awful scenario, being forced to quit your job.
That's constructive dismissal, and it's considered an unlawful dismissal.
How does that work?
It happens when an employer creates such a toxic, hostile, or unsustainable work environment that the employee has no reasonable choice but to resign.
That sounds incredibly hard to prove.
It's very difficult because the employee has to show that the employer's conduct was the direct cause, that it made resignation inevitable.
So these specialized representatives, they're operating in a really high-stakes environment. Extreme emotions, and these legal lines, unfair dismissal versus general protections versus constructive dismissal, are incredibly nuanced.
Exactly. And let me just underscore a critical finding from our sources here.
Please.
These specialized providers, they emphasize they are non-lawyer workplace and discrimination representatives.
I'm not lawyers.
No. They're masters of mediation, negotiation, arbitration, and representation, but They explicitly state they do not give legal advice.
So their focus is on strategy and process.
Yes, securing justice and closure through process and strategy without venturing into regulated legal practice. And that focus on getting the process right is what makes this next section so relevant.
That focus on human strategy is paramount, especially when you see what happens when people try to outsource that strategy to a machine. Yeah. Which brings us right to the first major case study, the pitfalls of AI reliance.
This is a truly cautionary tale for anyone tempted to use a large language model, an LLM, for something serious.
Yeah.
High stakes. We're talking about the 2025 case of Mr. Brandon Deisel v. Electrolift Co.
So what did Mr. Deisel do?
Well, Mr. Deisel was terminated from his job way back in October 2022.
Okay, 2022.
Then, 2.5 years later, in 2025, so 919 days later, to be precise, he decides to lodge a general protections claim under Section 365 of the Fair Work Act.
900 days later. And his confidence for filing so late came from where?
From advice he got directly from ChatGPT.
Wow. 2.5 years is an unbelievable delay, especially after what we just discussed about general protections claims being so time-critical. What did the AI miss?
It missed the absolute non-negotiable fundamental statutory deadline. We have to stress this for you, the listener. A general protections claim under Section 365 must be made within a strict 21 days of dismissal.
21 days versus 919. That's not a minor clerical error. That's a total failure of basic legal compliance.
It is. And the nature of the failure, it tells us a lot about LLMs.
How so?
ChatGPT works by generating text that is statistically probable to be correct based on its massive training data. It's not capable of checking specific, stringent procedural deadlines buried deep within Australian legislation.
It just generates plausible-sounding text.
Exactly. Plausible-sounding text that is completely worthless when you're facing the literal requirements of the Fair Work Commission, the FWC.
So how did the FWC react to his argument that he was just relying on the chatbot?
The FWC was unequivocal. They held a conference in August 2025 and described his claim as hopeless because of its deficiencies.
And they went after the AI use directly.
They did. They took direct aim at it, emphasizing the obvious danger of relying on AI for such critical advice.
And what about his excuse? That he was just ignorant of the deadline?
The commission statement was a stark reminder. Ignorance of the statutory time limit is, and they said this repeatedly, not accepted as a valid excuse for an extension. The claim was thrown out instantly.
And the ultimate irony, as our sources pointed out, is that the chatbot itself actually gave him a warning that he ignored.
That's the most telling detail of all. The FWC noted that ChatGPT had actually advised him to consult a legal professional or union representative.
It told him to talk to a human.
It did. And he dismissed that valid human advice in favor of the flawed legal arguments it also provided. The lesson is brutally clear. When the clock is ticking on a 21-day limit for a complex claim, you need human expertise and strategy, not probable text.
So we've established AI fails the individual employee. But you might be thinking, okay, surely that only affects people trying to cut corners.
Right.
But our sources prove this problem of AI failure, it runs right up the ladder. It causes catastrophic blunders for high-priced consultants and corporations.
Absolutely. If the Deisel case was a procedural failure, these next two cases are about failures of integrity and strategy.
Let's start with the recruitment pitfall, the Alexandra Frisbee Smith case. This one really highlights the tension between efficiency and authenticity.
This happened in June 2025. Mrs. Frisbee Smith, the systems consultant, was applying for a part-time job. As part of the interview, she got a 30-minute trial task. Devise a plan to streamline the employer's daily operations.
Okay, 30 minutes. That's a lot of pressure.
Immense pressure. So she used ChatGPT to help refine her solution.
Which, as a systems consultant, seems like a perfectly efficient use of a modern tool. She's just leveraging automation.
That was her defense. But she was rejected. The email she got cited heavy use of ChatGPT.
Seriously?
Yep. She pushed back, saying she was proud to use the tool as the most efficient way to do the task. And here's the smart part of her response. She noted the employer was able to recognize the AI typical formatting, which strongly imply they obviously use it as well.
Huh. That exposes a real corporate double standard. You want the efficiency of AI, but you punish the candidate who actually demonstrates that efficiency.
It completely blurs the line between using a tool to be more productive and using a tool to cheat. This confusion is everywhere in recruitment now.
But the financial stakes of AI failure get much worse when we look at the consulting world.
They get way worse.
Let's talk about the Deloitte incident. This involves government money and A just staggering failure of factual integrity.
This one is astonishing.
Hmm.
In August 2025, it came to light that Deloitte had produced a massive 237-page report for the Department of Employment and Workplace Relations.
What was it about?
It was an independent review of an IT system used to automate penalties for job seekers, and the report was valued at $440,000.
$440,000 for a report that was, what, essentially garbage generated by a machine?
That's the painful reality. The report was found to be riddled with AI hallucinations. Academics who reviewed it discovered around 20 fabricated references and citations.
What do you mean fabricated?
I mean non-existent research papers, books that were never published, and, this is the most damning part, a completely fabricated quotation attributed to a federal court judge.
Making up a quote from a judge and putting it in a $400,000 government report.
Yeah.
That's beyond an oversight. It undermines trust in the entire industry.
Absolutely. When the scandal broke, Deloitte had to issue a partial refund and republish the entire thing. They eventually admitted in an appendix that they'd used Azure OpenAI GPT-4o in its preparation.
So this case proved that if AI is allowed to operate without rigorous human oversight, it just generates plausible lies.
Plausible lies or hallucinations that can lead to catastrophic failures of institutional research integrity.
This sets the perfect stage for the biggest fear confronting workers today, AI-driven redundancies. We've seen job cuts across the major Australian finance sector, Telstra, NAB, ANZ, Westpac, the Bank of Queensland, all citing improved efficiency from technology as a key driver.
The efficiency argument is the driving force, especially for culling roles in back-office admin and customer service. But the most insightful story about the current state of AI in corporate Australia comes from the Commonwealth Bank, CBA.
Why?
Because it has this immediate and embarrassing twist.
Okay, let's start with the human cost before we get to the corporate panic.
In July 2025, the CBA announced it was axing 45 customer service roles.
And this was because of a new AI.
Yes, because of the successful integration of their new AI-powered voice bot named Bumblebee. Our sources highlighted the personal story of Catherine Sullivan, a 25-year CBA employee.
And the tragedy of her situation was that she actually helped create the system that made her redundant.
Yes, Mrs. Sullivan had worked in the customer messaging team, developing scripts, testing responses, essentially training Bumblebee in the years leading up to her termination.
She had that heartbreaking realization that she'd inadvertently trained the system that took her job.
It's a profound betrayal that so many workers helping with automation now fear.
But the CBA case is unique because the corporate backflip was so fast. Less than a month later, the whole strategy just fell apart.
The reversal was swift and humiliating. By August 2025, CBA was forced to issue an apology, admitting the redundancy decision was an error.
An error? Why?
The reason was simple. Bumblebee had not delivered on its cost-saving promise. In fact, it had led to rising call volumes.
Wait, a voice bot that's meant to handle calls actually increased the number of calls?
It did. The system was so inefficient, or maybe just confusing, that it forced managers to offer overtime and pull team leaders onto the phones just to cope with the surge in customer frustration.
So they needed more humans, not fewer.
Exactly. CBA officially conceded the 45 roles were not redundant after all, admitting they failed to factor in all relevant business considerations.
That must have sent a massive shockwave internally. It really highlights that the hype around AI is often driven by finance teams looking for cost cuts, not by the actual readiness of the technology.
That's the critical takeaway. The displacement threat is very real, but the current capabilities of these systems are constantly being overhyped to justify immediate cost cutting, which often leads to immediate strategic failure. It puts employees in this impossibly precarious situation.
So let's bring these threads of information together for you, the learner. On one side, you have the immense complexity and strict procedural requirements of Australian workplace law, especially the Fair Work Act.
Right, for claims like unfair dismissal and general protections.
And on the other side, we have these documented, high-profile pitfalls of relying on AI at every single level.
From Mr. Dyssel's procedural catastrophe with a 21-day limit, to Deloitte's corporate integrity failure with hallucinations, and the Commonwealth Bank's massive strategic reversal.
So the lesson is clear. For complex, high-stakes matters where strict time limits and procedural nuance are key, specialized human guidance isn't just preferred, it's essential.
The mistakes of the individual worker, the major consulting firm, and the big bank all stem from the same thing: placing unwarranted faith in a machine that generates text but can't comprehend context, consequence, or regulatory compliance.
We're seeing evidence that the Australian workplace is increasingly defined by a paradox.
How so?
HR managers might be predatory, corporate reports can be fabricated by unsupervised AI.
And yet, when the automated solutions are finally deployed, they often fail to replace the very human workers they were meant to displace.
So what does this all mean for the future of work? This is the final question we want you, the learner, to mull over. Our sources show us a systemic crisis of integrity and timing. The key question is this: how should fundamental institutions, like the Fair Work Commission itself, which demands factual and timely submissions, how should they adapt their processes and expectations in a world where foundational documents, contracts, and even the initial basis for serious legal action might be generated not by humans operating in good faith, but by rapidly evolving, error-prone machine learning models?
If the source material itself is suspect or delayed by algorithmic confusion, what happens to the justice system that's built on top of it?
Think about that.